The Union government on 21st November 2025 has notified the four labor codes. These are by far the most important reforms in the labor market since independence. What are the important changes announced by the government? What is the impact once these labor codes are implemented? Why many of the trade unions are opposed to these labor codes? Let's understand in this video. Hello and welcome to Unacademy IAS, a one-stop destination for all the English medium civil services aspirants. Before I start the discussion, let me make an announcement. 23rd November, we are conducting Mega UCSC. Anybody who is appearing for the Civil Services Examination 2026 must appear for this particular test. The test will be conducted in two slots, 11 a.m. and 5 p.m. Pick up any slots that is workable for you, attempt the test, and analyze what is the level of your preparation. And if you score very well, you get a chance to win a reward. Do not miss out. Register for the test using the link provided in the description below. Let me start the discussion. Let's understand certain basics first. In the Constitution of India, specifically under the 7th schedule, the subjects or the powers are distributed between the union government as well as the state governments. When you come to the subject of labor, the labor as a subject is mentioned in the concurrent list. What does it actually mean? It simply means the laws on the labor can be formulated by the union government, can also be formulated by the state governments. And this has actually led to a lot of complications in Indian labor market. Reason being, according to one estimates, there are more than 100 labor laws in India. And when you have more and more labor laws, for companies, it becomes very difficult to implement all the provisions. The compliance burden increases, that is the cost associated with implementation of the labor laws. It creates a lot of confusion. And this is not just applicable to the companies operating in India. The investors who want to invest in India are also worried about falling into this particular trap of following multiple complicated structure of labor laws. And in the context of the workers as well, many of the times the workers do not understand under what law and under what provision they are covered, to what extent they are protected. Are they supposed to get the social security benefits? If yes, under which law, etc. And that is the precise reason the government of India has decided to rationalize the labor laws. And when you look at the government of India's policies, please understand this. It is not the first time that the government of India is rationalizing any kind of a structure in India. Earlier, the government of India has rationalized GST, and now 29 labor laws of the Union Government of India have been taken and have been clubbed, have been made into four labor codes. What are the important provisions of the labor codes? We will understand in some time. But this argument of rationalization of the labor codes was actually recommended by the Second National Commission on Labor, second NCL. This was set up when Mr. Atal Bihari Vajpayee was the Prime Minister back in the year 1999, and they submitted the report in the year 2002. In fact, it was this particular commission which recommended that there are multiple labor laws in India. There are plethora of labor laws in India complicating the whole labor market. And this commission recommended that we must reduce the number of labor laws to maximum 4 to 5. And before I go forward, I know some of you will be thinking, sir, who was the chairperson of the second NCL? And the second question that will be lingering in your mind will be, if this is a second commission, when was the first commission set up? Let me address both of those questions before going forward. The second NCL chairperson was Mr. Ravindra Verma. Please remember the name, can be asked in the UPSC examination. It was headed by Mr. Ravindra Verma. And the first NCL, that is National Commission on Labor, was set up back in the year 1966, and it was headed by Justice Gajendra Gadkar. It was headed by Justice Gajendra Gadkar. Done? So these are certain important points. Now come to the current affairs. The government of India, like I said, looked at the labor market and has already implemented multiple labor reforms. For example, it has implemented reforms in terms of promotion of internship in India. It has promoted reforms in order to generate jobs in India. It has implemented reforms in order to skill labor in India. And another very important reform, and I hope you understand this. This reform is by far the biggest since independence in the labor market, is the rationalization of the labor laws. The state government and the central government put together, the total number of labor laws are more than 100. Now the union government has taken 29 of its labor laws and has basically subsumed all of them, has packaged all of them, that is the 29 labor laws, into 4 labor codes. These 4 labor codes are: 1. Code on wages. Second one, Industrial Relations Code. Industrial, after that, Code on Social Security. And the fourth one, Occupational Safety, Health and Working Conditions Code. Please memorize all the 4. And you do not have to write all of this thing down. Once the session is uploaded on the YouTube, I'll be uploading this particular PPT along with annotations in the Telegram channel. Please download it from there. So these are the 4 labor codes which have been formulated by subsuming 29 labor codes of the union government. Again, I repeat, union government, not of the state governments. Now, what is the importance of all of these particular 4 labor codes? The first, code on wages, will basically reform the structure associated with changes in how wages are calculated, right? And many of the provisions associated with the bonuses have been brought under this particular code. Second one, code on social security. It will extend the social security benefits to many of the workers who were not covered until now. And I'll discuss this one by one. Have patience. Third one, industrial relations code. This particular code has brought in all the laws, all the provisions associated with the disputes, right? Or industrial issues, governance, etc. related to the industries. And the fourth one, occupational safety. It is consolidating 13 existing central laws related to the safety, health, working conditions in the companies or in the factories. Now, rather than looking at these particular individually, because there are more than 450 provisions in all the 4 labor codes, let's understand individually how these labor codes will have impact on MSME, will have an impact on the contract workers, will have an impact on the women workers, etc., etc. But before that, what was the need to formulate, or let's say address or implement these labor reforms? Listen to me very carefully. Many of these labor laws, which have been subsumed into 4 codes now, these were formulated before independence as well as immediately after independence. For example, the Industrial Act, right, the Disputes Act, or the Trade Unions Act was in the year 1926, the Factories Act in 1948. So the policy that was followed by the union government back then was completely different. What was the situation of Indian economy back then was completely different. The economic structure in India was completely different. And the scope of the private sector participation was very limited. For example, you must have heard of Industrial Policy Resolution of 1948, Industrial Policy Resolution of 1956, wherein very limited amount of space was given to the private sector to operate in India. Most of them were covered, were controlled under the union government, especially with the implementation of Industrial Policy Resolution of 1956. But post 1991, the government of India implemented LPG reforms, liberalization, privatization, and globalization reforms. And with that, we not only promoted the private sector participation of domestic companies, we also promoted the foreign private sector participation in India. And whenever you want higher private sector participation, they would want a lot of flexibility. They would want easier labor laws. This has actually led to, over a period of time, the government of India considering to ease the labor reforms or labor laws. And finally, these particular labor codes were announced by the union government, were passed through the parliament, and in the process of passage, they were sent to the standing committee as well. And back in the year 2019 and 2020, these were passed, and finally, these have been notified by the union government. Now, although there is a lot of discussion associated with whether these are going to benefit only the workers or is it going to hurt the workers' interest. Please understand there is a balanced approach which has been undertaken by the union government. What is the concern? What are the benefits? We will understand now. Let me start the discussion regarding what are the important changes that will take place once these will be implemented. Let me start with the first group of workers, the gig and platform workers. In the context of India, no doubt, in the last couple of years, the gig economy has been booming. According to Niti Aayog, millions of workers are employed under the gig economy, and there is a rising demand for the gig workers as well. But at the same point of time, the concern has been that the amount of revenue that is earned, amount of income that is earned by these workers in the gig economy, it is not sufficient. Now, what has the, let's say, these particular four codes, what has it provided? What are the provisions which have been provided for the gig and platform workers? Let's understand them one by one. Definition for the first time has been provided for what is a gig work and what is a platform work, aggregator, etc. For example, under these codes, now the gig work will be defined as a contract, or let's say a kind of work arrangement, that is existing between an employer and this particular gig worker, which is not a traditional job offer or which is not a traditional agreement. What do you mean by traditional arrangement between the employer and an employee? If you join a company, the company will give you an offer letter. In the offer letter, they will give you all the details. You'll be guaranteed certain amount of salary every month. You'll be provided with lot of hidden benefits. For example, EPF contributions, maternity benefits, etc. But all of these are generally not provided for the contractual workers and gig workers. Gig is again associated with the contractual work itself. So these kind of benefits are not provided. And moreover, right now there is no definition how to define who is a gig worker. So listen to me very carefully now. The first very important change. Who is a gig worker? What is a platform? Who is an aggregator? All of them have been defined under these labor codes. And even before you go forward, remember this point as well. Many other states already have proposed the laws or have implemented announced laws wherein these kind of platform workers have already been covered. So first, definition has been provided. Second one, like I said, a lot of times we see that these gig workers do not get any kind of a social security benefit. It could be EPF, it could be other kind of a social protection, etc. These are not provided with these kind of social security coverage. Now, under the labor codes, the aggregators will have to contribute 1 to 2% of their total revenues. There is no option. They will have to contribute 1 to 2% of their total revenues to a welfare fund, and that would be utilized to provide social security benefits to these particular workers. The maximum amount of contribution has been pegged at 5%. Third one, what if I'm working, let's say, as a gig worker, as a contractual worker with one company, and I finish the work. Now I'll be employed with another company from another state. Now, in that particular case, if I've got social security benefits, for example, right, let's say if I've got UAN number, universal account number, which is associated with your EPFO contributions. What if I move from one employer to another employer who is coming from another state? In that particular case, will there be any issue with transferring or any issue with the portability of this UAN number? Absolutely no. The government under the labor code simply says these are portable. These are portable in nature. You do not have to be worried about moving from one employer to another employer. So this is right certain very important, or these are some of the very important changes that are being implemented or have been proposed by the government of India under the labor codes. Now, what about the fixed term employees, FTEs? What is an FTE, by the way? Let's say I'm being employed by a company, not as a full-time worker. Full-time worker means I'll continue to work as long as either don't quit or either I quit or the company removes me. That's a full-time worker. But what if the company is going to hire me for 2 years, for 3 years, or 1 year? These are called as fixed term employments. Fixed term employments. And whenever an employee is covered or has been hired under the fixed term employment until now, I repeat, until now, social security benefits were not provided to them. Social security benefits, I repeat, were not provided to them. Now the government of India simply says once an employee is a fixed term employee, the same social security benefits which are available to a full time employee shall be extended to this fixed term employee as well. Shall be extended to this FTE as well. This is the first very, very important point. Second, very important point. Whenever you join a company, you will get certain amount of gratuity upon leaving the company. Now this gratuity is available only when you provide services for 5 years for the company. Now the government simply says in the context of fixed term employees, even if you provide, let's say, services for 1 year, 2 year, doesn't matter. If it is even for 1 year, yes, they will be eligible. They will be eligible to get gratuity. Second very important change. Third one, whatever wages are paid to the full term employee for the same work done by a fixed term employee, same wages shall be paid. And please remember, the labor codes basically are promoting gender neutral wages. What do you mean by that? Whether in this case or even in the context of women employees, the labor codes mandate that for the same amount of work done, for the same job, same salary shall be paid. Same wages shall be paid. So ensure equal wages and reduce excessive use of contract labor. And finally, the contractual workers, the workers on contract basis who are working for these companies, they will be provided with annual health checkup as well. They'll be provided with annual health checkup as well. In the context of the employment as well as unemployment, remember another very important point is mentioned in the labor codes. Generally, whenever you talk about a company trying to shut down, close the operation, or remove the employees, etc., there is a requirement of a minimum threshold of number of employees. What do you mean by that? Until now, if you have 100 employees and you want to shut down the operation, you were supposed to go to the government authorities, take the permission. Now, this particular number has been increased to 300. If you have 300 and above employees, only then you will go to the government authorities and take the permission. Otherwise, it is not at all required. It is not at all required. This has been done by the government to basically promote ease of doing business. Compliance burden will become much, much lesser for the companies. So first group, the platform workers as well as the workers who are classified as gig workers. Second group, the fixed term employees. Let me go to the third group, that is the women workers. Until now, there are multiple labor laws which prohibited participation of women in certain types of jobs, in certain types of work opportunities. These were generally classified as hazardous works, hazardous jobs. Now the government of India under the labor laws has completely removed this particular restriction. The women workers are allowed to work even in these particular hazardous jobs. They are allowed to work in the night shift as well. But of course, the government under the law says, first you will have to take the consent of the women workers and you will have to provide efficient protection, that is security. The consent is required as well as the company has to provide sufficient security in order to protect the women employees. Gender discrimination is prohibited under the labor codes. What do you mean by this? There have been multiple instances reported even in the recent past, wherein certain companies, I'm talking about one instance where Foxconn was alleged to have been done this. There was an instance where it was stated that or alleged that the company Foxconn is asking the women employees their marital status, and based on that they are deciding whether to hire them or not to hire them. Generally, the allegation in such cases is that the employers do not want to hire the married women who do not have, let's say, children as of now, because their concern is again not right. It is a discrimination right now. The argument is very simple. The employer says if the person who is married doesn't have children now will get pregnant, then the maternity benefits will have to be provided. right? A lot of paid leaves have to be provided, and right, the person or the company has to take care of these activities by allocating the work to somebody else. Is it correct? Absolutely no. But now under the labor codes, gender discrimination shall not be allowed. It will be prohibited under the law. And not just this, equal pay for equal work. This was very much needed, by the way. One of the ways you need to, basically, you can promote gender equity in the society, gender, right, equality in the society, is by making sure that same amount of wages are paid for the same amount of work that is done. In fact, in the recent past, this has been there in the discussion. The BCCI has led by example. The match fees that is paid to the male cricket team is the same that is being paid to the female cricket team as well. But anyways, now under the labor codes, equal pay for equal work will be ensured. Women will be allowed to work in the night shift and also in all the sectors, even including in the underground mining. Right? Even those hazardous activities, now there is no bar on employing women, they can be employed. Mandatory women's representation in the grievance committee. What is the importance of this? There are multiple instances in a company or in a manufacturing facility where the women are harassed. Women are harassed mentally, physically. There are a lot of issues that will arise because of certain superior or inferior workers or low level workers. Now, many of the times, women do not prefer to go to the grievance redressal committee. Right? Reason being, it has been seen that a lot of times the committee which is expected to take up the complaint, hear the complaint, and resolve the issue comprises all the male workers. All of them are male subordinates. In such cases, women generally do not prefer to file a complaint. Now, a grievance redressal committee, GRC, which has to be set up under the labor codes, has to have up to 10 members. And whatever the total number of membership is, half of them have to be male, half of them have to be female workers or female, right, representatives. So that the female workers, whenever they face these kind of issues, they will find it very easier to approach the female workers in the grievance redressal committee and file a complaint. That is another very important change. Fourth one, family definition has been expanded to include parents in law. What is the meaning of this? Whenever you talk about women workers, what if the women worker is covered under ESIC, right? That is employees state insurance. Now, until now, right? And again, now the new codes have been right have been announced. Under the earlier labor laws, the husband and the children were covered. For example, let's say healthcare facilities, right? Or healthcare has to be provided, or right, compensation has to be paid. Generally, we used to cover only the husband and the children. Now, the definition of the family has been expanded. Even the mother in law as well as the father in law of the women worker will be included. And what is the benefit of it? Whatever provisions are there covering the workers, or let's say the family of the workers, now the coverage will be extended even to the, right, let's say the mother-in-law as well as father-in-law. And this is a recognition of the concept of the joint families in India, because you must have seen in many of the families in India, and generally this is the, right, let's say practice. The let's say the woman goes to work, the husband is also going to work, both of them, both the spouse are going to work. They generally are in a, right, let's say joint family setup. So not just the husband and the children, now father and mother-in-law will also be covered under these kind of, let's say, benefits which will be provided. Next group of, right, let's say beneficiaries, MSME, MSMEs. All eligible MSME workers covered under the Social Security Code now. Whatever social security benefits are provided for other companies' workers, now upon notification will be extended even to the workers under MSME. And why is this important? A lot of times these particular social security benefits which were provided through a law, through, right, let's say a law, used to have a threshold requirement. That is, the company should be having, or the unit should be having more than 10 employees, more than 20 employees, etc. Now all of that will be removed. Once the government notifies this, the workers in the MSMEs will also be covered under the social security benefits. Minimum wages, basic working facilities, standard working hours, that is generally in case of India, please remember this. The working hours decided is 48 hours. According to the law, the working hours in a week are 48 hours. No matter what, or let's say what the business leaders say, right now, according to the law, it is 48 hours. So the basic facilities in the manufacturing unit, the standard working hours, as well as whenever there's a overtime done, double the payment has to be done, right? These are some of the provision. And timely payment of wages are mandated, and not just for MSME workers. This is a very important announcement applicable even to other workers as well. For example, if you're a software engineer, now under the labor codes, the company is supposed to pay your salary in the first 7 days of the month. First 7 days of the month. They cannot delay beyond the first 7 days of the month. So these are some of the very important reforms announced in the context of micro, small, medium enterprise workers. Now, what are the other important changes announced? What are the other important, certain other very important changes which will be implemented? Single registration, license, and returns, sharply reducing the compliance burden. What is the meaning of it? Many of the licenses which were required for the companies to operate, to enter into certain activities, to hire people, etc. Rather than having multiple requirements or multiple approvals, multiple licenses, etc., now only one license is required, or single registration for multiple or under multiple laws. Single licensing requirement will be the norm. And what is the use of this kind of a reform? Whenever the government announces these kind of reforms, I'll just give you one more example to make you understand. Earlier, you want to set up a unit in India. Now, in order to set up this particular unit, you were supposed to take approvals from different departments, different ministries, right, and different state government departments as well. The government of India says now it is not required. Why? The government of India has announced a system called as National Single Window System. That is basically going to have a single window, right? Let's say clearance. All the clearances from the union government that you require, you can apply it through this particular window or facility and get the approvals. This is going to reduce, right, the Herculean task of running from one ministry to another ministry, one department to another department. And at the end of the day, this is going to promote investments in India. This is going to make easier to conduct business in India. This is exactly what the government of India is trying to do under the labor codes as well, right? So simplification of lot of these, right, norms, the reforms have been done now. Pan India ESIC coverage, including for small as well as hazardous establishments. I told you earlier, ESIC was not applicable, was not covering, right, a lot of these particular workers, because the argument was certain thresholds will have to be met, certain conditions have to be met, etc. Now government says not required. ESIC will be applicable throughout India. National floor wage, which will ensure no workers' wages will fall below a minimum living standard. What is the meaning of it? The union government announces a national floor wage level. And this will be different, right, according to the operations or the kind of jobs you are doing. And in many of the cases, it has been found that the workers who are employed earning wages, the amount of money they are earning is not sufficient. Whatever is the amount that is paid to them is much lower. It is not sufficient to basically conduct the day-to-day operations, such as not sufficient to have 2 square meals a day. Now government of India says, henceforth I will announce a national floor wage, and anybody who is working in India, the wages are paid to them. The amount of wages that is paid to them shall not be lesser than the floor wage that is decided by the union government. Right? I hope you understand. It will not be lower compared to the floor wages that are announced by the union government. Right? So these are certain very important changes that have been announced by the union government through the 4 labor codes. Now, what is the government of India trying to achieve with these labor codes? One, they should be very clear to you. They want to promote ease of doing business in India. And easier it is to conduct business in a country, you can expect not only the domestic investments but also foreign investments. In addition to this, lot of interest of the workers, lot of sections of the workers have been covered under this. For example, women workers, contractual workers, even for that matter, there is one provision under the labor codes which says the workers who are above the age of 40 years, now they will have to be provided with health checkups. They will have to be provided with health checkups annually. So workers, full time, part time, right, or contractual workers, wage workers, women workers, right, the fixed term employment workers, and even the gig workers, a lot of them and their interest have been protected under these particular labor codes. In addition to this, the government of India has also announced that how the wages will be calculated under these, that is code on wages, how the wages would be calculated would differ now. And if you're wondering, sir, what is the impact of that? Whenever a gratuity is decided to you or whenever certain contributions are decided to you, usually you take the basic pay. Because when you earn a salary, imagine you join a company and you earn a salary, the basic pay will be limited and many other allowances are added to the basic pay. Reason that the companies structure your salary in this particular way is that lot of the things are decided based on the basic wages itself. Now government says don't worry, the way the basic wages would be calculated, sorry, the way the wages would be calculated in order to calculate these kind of benefits for you, the way the wages would be calculated now would be different. Rather than simply taking the basic wages, now I would be taking the basic wages plus many more allowances along with that. So with that, right, a lot of the benefits that you are expected to get would also start to increase now. So these are some of the very important changes that are expected to come into force once these laws will be implemented. But having said so, there are multiple stakeholders, for example, trade unions, who have raised concerns associated with the labor codes. And they have raised concerns. What are the concerns? Let's understand certain important concerns. One, the trade unions are basically saying the consultation process was not conducted correctly by the union government. Right? A lot of these particular provisions, right, have been implemented. Lot of changes have been, right, announced by the union government. These have not been done by holding proper consultation. Trade unions should have been taken into confidence. What recommendations have been provided by them have not been taken into confidence and changes have not been done, etc., etc. In fact, in the beginning of the labor code announcement, when the, right, let's say the passage was being done, there was also criticism stating that the opposition parties were not there. But that's not important for a simple reason. It's not that the bills were rammed through the parliament. No, standing committees where there is a representation from other political parties have looked at, have recommended changes to these labor codes. So one criticism is that sufficient consultation has not been conducted by the union government, though the reforms are very important, are going to have an impact on all the workers in India. Second, collective bargaining. The bargaining provisions which have been implemented in the labor codes, they are going to weaken the collective bargaining. What do you mean by this? There is a provision associated with trade unions. Earlier, we had Trade Unions Act. Right now, all these provisions associated with industrial disputes, trade unions, etc., they have been brought under one of the labor codes, that is industrial relations. Now, the criticism is that in this particular situation, the provision that has been announced by the union government, that is there in the code, is that whenever there is supposed to be, right, let's say a discussion between the management as well as the trade union. Now, how the trade unions are formed, the condition has been changed. It simply says, the law now says, the code simply says, you will have to have 100 employees or at least 10% of the total number of workers. Now you will be allowed to form a trade union. That's the first one. And earlier earlier act simply said, you need to have at least 7 workers. And the second biggest issue that has been raised by the trade unions is that whenever there is a dispute between the trade union as well as the management and the consultations have to be held, the one or the group of trade unions which has majority of the workers, I repeat, majority of the workers, they will be, right, basically recognized by the management, and they will hold consultations with that particular group. That is 51% or more than 51% of the workers are part of the trade union. Right, so that will be the, right, let's say one trade union. What about other trade unions which are legally recognized but have very small number of workers? They're not part of this particular, right, let's say the trade unions which have 51% of the members or the workers. They are smaller trade unions, so their interest would be neglected, right? Their bargaining power would become very minimal now. So that is a concern that has been raised in the context of trade unions. Job security, like I said, 300, earlier it was 100, right? That is, you want to close, you want to remove employees, you are supposed to take permission. Now this has been increased to 300. The argument of the government of India is that because it was earlier 100, lot of the companies did not hire 100 full-time employees. They did not hire. Why? If I hire 100 employees in one company, I will have to comply with all of these laws. That is, if I want to remove, I'll have to take the permission of the government. If I want to shut down, I'll have to take the permission of the government. Now let me scuttle, let me escape from this. What will I do? I will set up two units with one having 80 employees, another having 50 employees. So totally under my ownership, two companies are there having more than 100 employees. But because the law is applicable, if the manufacturing unit or this unit has more than 100, none of my units will have more than 100. That could be done by me. Or else, imagine I'm somebody who is going to supply, but this is very periodic supply. That is, let's say in certain season, only in certain season I want to supply more, right? For that, I will not hire more than 100 employees. I'll simply outsource this to, right, let's say another country or another company, rather than hiring more number of employees beyond 100. So the government of India looked at it and looked at this situation and simply said, let's reform this. Rather than having a threshold of 100 employees, let's increase this to 300 employees so that the companies will not be worried. But at the same point of time, now the concern is that trade unions are simply saying, because you have increased it to 300, above 300, they will come to you to fire an employee. Below 300, now they can easily fire the employees. Right? So job security of many of these employees, which was not a concern earlier, because of the rise in the threshold, has become a concern. That is one more criticism. Next one, the idea of labor reforms was announced. And with that, it was expected that under the labor codes, the powers will be given to both center as well as state. Both the interest of the stakeholders, both of their stakeholders' interest would be protected. But many trade unions are criticizing the labor codes because most of the powers under these labor codes have been concentrated with the union government. Their criticism is most of the powers are concentrated in your hands. Then what is the role of the state governments? Right? Very minimal, negligible. So you have concentrated, or you have basically usurped most of the powers with you. And next, in many of these labor codes, in order to promote ease of doing business, the government of India promotes the concept of self-certification. In the context of, right, let's say the visits or inspections, a new system has been proposed. In many other provisions, a self-certification has been promoted by the union government. The basic idea is, don't worry, you declare that you're following the guidelines. You simply declare yourself that you're following the guidelines. I will not be interfering in your operations. That is basically idea of a self-certification. Now the concern of the experts is that if you ask them to self-certify, you're basically asking the company which is supposed to be evaluated to evaluate itself. I'm supposed to evaluate myself. I am only evaluating myself by self-declaring. Right? That might actually lead to abuse of resources, exploitation of the resources. The companies might simply on paper say we are implementing the regulation, but in reality, they may not be implementing, they might be violating these particular regulations. So these are some of the criticisms that have been leveled by the trade unions against these four labor codes. But nevertheless, you'll have to remember one particular point here. That is, Since independence, multiple reforms have been implemented by the government of India. But by far, in the labor market, this has to be one of the most important reforms. The biggest reforms in the labor market, which will not just have an impact on the labor market. That is, yes, automatically it will have an impact on the labor market, but the impact will be spread to the overall Indian economy. So, in that particular context, were these reforms required? Of course, yes. But is it the end of the reforms? Absolutely no. Reason being, the reforms have been notified by the union government. Now, the detailed rules will have to be framed. The other stakeholders, such as the states, will have to be brought on the platform. That is, will have to be talked to, and then the implementation has to be rolled out. So, it is not the end of the reforms, it is merely the beginning of very important reforms. Now, associated with the discussion that I've had so far, I'll give you one MCQ assignment. The question is, consider the following statements. Two statements are given. The labor falls in the concurrent list under the Constitution of India. The second National Commission on Labor was headed by Justice Gajendra Gadkar. How many, or let's say, which of the above statements is or are correct? Is it only the first statement, only the second statement, both, or none? What is the right answer? Do let me know the right answer in the comment section of the video. And if you've got the benefit of the discussion that I've had so far, if I've gotten any kind of a knowledge regarding the labor codes that I've discussed so far, do not forget to hit the like button. If you're yet to join our YouTube channel, kindly do it right now. Thank you. Have a great day.